Hello, everyone. There's a new development in the Council of Europe, and this one is again on Osman Kavala. Held behind bars since October 18, 2017, namely nearly 9 years, Kavala's case is widely regarded as symbolic for Turkey's thousands of political prisoners. A philanthropist and a civil society activist, Kavala is sentenced to aggravated lifetime imprisonment without a parole, that is, held at solitary confinement. Number of political prisoners, that is rather blurred, but Ömer Faruk Gergerlioğlu, deputy of Dem Party, and for long the follower and monitor of human rights breaches in Turkey, mentions the number in an interview with me as at least 40,000 held in jail for deeply disputable or disputed charges. Wednesday, 22nd of April, 28 deputies from various member states of the Council of Europe presented its parliamentary assembly a motion for resolution aimed at speeding up the case of Osman Kavala. They call for Magnitsky sanctions for all Turkish officials they point as responsible for deprivation of his liberty, unquote. The call is also extended to the European Union member states. The brief text is as follows. It's worth reading. In two rulings regarding Osman Kavala, the European Court of Human Rights found Turkey in violation of Article 18 of European Convention on Human Rights, implying that the proceedings against him constituted a misuse of the criminal justice system with the purpose of silencing him, as in the case of Selahattin Demirtas, i.e., Kurdish politician, held also in jail since November 2016. In another landmark judgment, the motion text goes, demonstrating the absence of the rule of law in Turkey, Yalçınkaya versus Turkey, the court ruled that principle of nullum crimen sine lege, referring to no crime without a law principle, guaranteed under Article 7 of the Convention, was breached in a systemic and widespread manner so as to concern more than 8,000 pending cases before the court and more than 100,000 cases before the Turkish courts. Despite the court rulings of 2019 and 2022, including that following the infringement procedure launched by the Committee of Ministers, Osman Kavala is still being kept behind bars. In 2023, the Parliamentary Assembly called unequivocally for release of Osman Kavala, noting that this truly exceptional case is undermining the basis of the convention system as a whole. Turkish prosecutors and judges and other officials who dealt with Osman Kavala's case are jointly responsible for his unlawful detention through the misuse of law. The Assembly should, the signature holders claim, therefore follow up. It's called contained in resolution dating 2023 on Council of Europe member and observer states and the European Union to apply their Magnitsky legislation or similar legal instruments to impose targeted sanctions against those officials, including prosecutors and judges, who are responsible for the unlawful and arbitrary deprivation of the liberty of Osman Kavala. At the end of March this year, Kavala's case was raised in a historic session at the Grand Chamber of the European Court. And now, this move. How to read what's happening? Will the motion find its way to implementation? Roadmap? Question mark. What, if so, will be the consequences? To go into details, I am joined by the former Turkish judge, Yavuz Aydın, a board member of the International Justice for Rule of Law group based in Brussels. Good to have you here. Welcome.
Thank you. Thank you. Thank you for having me.
So, what is happening in the Council of Europe? Please go into the details. Explain it to us, please.
First of all, as you have rightly stressed, that this is something unprecedented. So there was no such thing, as far as I know, to the best of my knowledge, happening about any other country in the Council of Europe, because such a thing is new to Council of Europe and to the European Court of Human Rights.
It has never
Normally,
happened before.
never happened before.
Mhm.
Never happened such a thing, because Turkey is now unfortunately the country of the first experiences and examples, not the good ones, but the bad ones for the Council of Europe, and being the only and the first country which has been demoted to monitoring status
Mhm.
after 13 years again. This is something unprecedented, and being the only country against which there's this infringement procedure for failure to implement the two judgments of European Court of Human Rights about Kavala, and now this third is now in the pipeline, and now this.
How is this happening?
So it didn't happen overnight, of course. From 2019 and 2022, there are two decisions of the European Court of Human Rights against Turkish government, which is about Turkey's failure to abide by its undertakings under the European Convention on Human Rights, namely about Osman Kavala. But Osman Kavala is only an example of this attitude, I can say, this approach. And in the motion for resolution, as you already read, there are two other names mentioned in the resolution, motion for resolution. These are Selahattin Demirtas, who is now in jail for more than 9 years now, more than maybe almost 10 years.
In November this year, it will be the 10th anniversary.
10th, yes. Long time for such a brilliant politician who had almost 13% of the votes in Turkey for the presidential race in 2015, was it? No. Yeah. So
2015, yes. 2015
yeah.
June elections.
Yes. Selahattin Demirtas and also Yalçınkaya. And about Yalçınkaya, the reason why they had this Yalçınkaya example as a paragraph in this motion for resolution is that this demonstrates another phase in arbitrariness. Because in Yalçınkaya case, just to remind a little bit, the ECHR, European Court of Human Rights, said that Turkish courts just ignored Article 7, which means that there cannot be punishment without a crime, nullum crimen sine lege, which is the backbone of any rule of law and democracy. So this is the backbone of justice, actually. And the reason why Yalçınkaya is so important is that the court itself, in its ruling, literally said that this breach is valid for more than 8,000 pending cases before the ECHR, plus more than 100,000 cases pending before Turkish courts, which will eventually arrive at Strasbourg.
As I read in the text, yes, that's in the main text. Right.
This is really such a catastrophic situation, and although these cases are being examined by the court as groups of cases, so to say, 2,000 cases appear as one file in the statistics of the court. Despite this, the percentage of cases coming from Turkey before the ECHR, its weight is enormous. It's 37% of the whole pending cases before the ECHR are coming from Turkey. So this is the weight we are talking about.
But I'm wondering why it went so far as to call for Magnitsky sanctions. If it is a unique case, please enlighten us about this. Why has it come to this?
Yeah, because about Kavala case, this is something about Article 18, which is, as in the text, as mentioned in the text, Article 18 means that the courts acted with an ulterior purpose, which is politic and political motivation rather than the judicial motives. So this is the end of the justice in any country, actually. So this is such an important breach, and the number of Article 18 breaches in the history of the ECHR, to the best of my knowledge, it's not more than 23, and almost 13 are from Azerbaijan, and now 2 are from Turkey, about Kavala and Demirtas. And about Kavala, this has been a landmark decision because it also has dimensions about freedom of speech, about freedom of assembly, media freedom, and all other, and right to privacy, fair trial. All these rights will be evaluated again by the ECHR in the pending case before the ECHR. The hearing was held in March 15, so March 25th, before the Grand Chamber. So this is such a landmark decision, and Turkish authorities, unfortunately, did not abide by the ECHR decisions.
I am
And
wondering,
that's
I am wondering here, 28 signature holders. Uh,
yes,
Minimum requirement was how many? 5,
20,
10,
20,
20. So 28
20.
of them.
Yeah.
And this could have been more, but
Yes.
28 was seen as enough. Among them,
Yeah.
I saw the list, the former
Yeah.
Greek Prime Minister Papandreou, Yorgos
Yeah.
Papandreou, and also Adam Bodnak, former
Ordinary. Yeah.
Polish Bodnar, uh,
Hmm.
excuse me, Adam Bodnar, former Polish Minister of Justice, and many other
Yes.
heavyweight names are
Yeah. Yeah.
among them.
Yeah.
So please explain us what will happen now, because this is a unique case. Probably nobody knows what will happen.
So what will happen is that procedurally, the Presidential Committee of the Parliamentary Assembly of Council of Europe will decide to which committee this motion will be referred to.
Mhm.
And the committee, which will be in charge, will have a rapporteur, and the rapporteur will prepare a report about this situation. Because as also another complementary answer to your previous question, there was already this infringement procedure in place because of non-implementation of the Kavala judgments by Turkey.
Mhm.
So, despite this, Turkey dragged their heels to
Mhm.
implement these judgments, and this was like another phase already in 2023 to recommend such sanctions. And Turkey did not just take it serious. And now that Kavala has still been held in prison even after
Mhm.
2023, now a second call to reiterate this decisiveness at the side of the Strasbourg Council of Europe is now here in this motion. So this is
So,
a more specific and a call to reiterate the already existing call of 2023. And now the committee and the rapporteur will just prepare a report about some certain names, mainly judges and prosecutors, to be held responsible for
mhm.
this failure and
Mhm.
to be subject to Magnitsky style sanctions, which are like ban on entry to EU countries and Council of Europe member states also, and freezing of assets and freezing of bank accounts and freezing of bank transfers, such things.
Within the European Union domain, that is to say,
Uh,
the
Normally,
assets, etc.
the call is Council of Europe wide,
Mm-hmm.
including all 45 other countries,
Mm-hmm.
excluding Turkey. But it calls EU and EU member states and Council of Europe member states and observer states on taking action. So normally, all these are interlocutors. All these are addressees of this call. But
Mm-hmm.
what's most important thing here is that the main addressee here is the EU, European
Mm-hmm.
Union. And on behalf of the European Union, the European Parliament to take action about
Mm-hmm.
this. Because now, after the second call, which definitely demonstrates a grave situation here, they
Mm-hmm.
cannot just turn a blind eye to this. They
Mm-hmm.
cannot ignore this, because in the Article 2 of the treaty establishing the EU says that the union is based on common values like democracy, rule of law, human rights, and so on and so forth. So in this case, especially after the repeated second call, that would be denial of itself for the EU. So they will have to act somehow. So we will see the magnitude here. We will see the level of this reaction from the EU side, but namely and mainly, the main addressee is the EU and European Parliament.
What is the time frame here? When will this happen? When is the
Uh,
rapporteur handing over the report, etc.?
yeah,
Because this case, as far as I remember, is being dragged for years and years
yeah.
at the European Court and the Council of Europe floors, etc. So, what is the time frame?
Roughly speaking, it goes from 6 months to 12 months, I can say,
Mhm.
to have a result, a voting in the assembly, General Assembly
Before the
of the
voting,
Parliamentary Assembly
will
of Council.
The Turkish government be asked to lay its wording as well?
Yeah,
Its
of course.
view as well? Mm.
Of course, there will be hearings and in the Legal Affairs and Human Rights Committee, even before the assembly phase, there are members of Turkish delegation coming from different
Mhm.
parties, political parties in Turkey. They will also have their say,
Mhm.
including the ruling party, AKP and MHP. So they will have to just raise their objections and their arguments also. So these all will be discussed and there will be the report. But I want to underline a fact here. It's not only about having a report in a committee of the PACE and having a voting in the General Assembly of the PACE. Even the very existence of this motion, which is now formal and on the website of the Council of Europe, with the signatures of 28 leading figures in the PACE, it already has a strong meaning, and it already must have sent a strong message to Turkey also, because this is, as I said, unprecedented, and there's no other example. And this is directly targeting judges and prosecutors who have signatures under the arrest warrants or the decisions or refusal of the release requests of Osman Kavala. And these names are really some flash names, I can say, in
Mhm.
Turkey. For example, the current justice minister, he has been appointed as the justice minister, I think, like less than 2 months ago. Until then, he was the chief prosecutor of Istanbul. And before then, he was the presiding judge in the heavy crimes court in Istanbul. And he is number one. He should be the number one in the list about the sanctions, Akın Gürek. And the second one, as far as I could see on open sources, on media, is İrfan Fidan. İrfan Fidan is currently...
It was widely reported that certain judges and prosecutors in open sources in Turkish media as well.
Yeah, yes. More than 13 judges and prosecutors at first hand will be responsible for this and will be subject to such sanctions.
You said more than 13.
Yes, as this is the number I could find on internet, on open sources, because there are many decisions about Kavala. The first arrest warrants, and then the refusal of release, and then the convictions, despite the existence of the ECHR ruling about his release, his immediate release. And afterwards, the second indictment, and then the second arrest warrant, and then the Court of Cassation phase is also included. And the members of the Court of Cassation in the relevant chamber of the Court of Cassation. And one of those members are now the chief prosecutor of the Court of Cassation. So Mohsin Şentürk. And these names, and also one of the former Vice Minister of Justice, Hasan Yılmaz, should also be in the list, I think, because he was also he has also his signature on one of these indictments as the deputy chief prosecutor of Istanbul of the time. And this also tells us something. If you look at the profiles of these people I just gave as an example among the others, all these people have been promoted to these strategic positions and these high-level positions after playing their role in Kavala case. And one more thing to note, worth noting, is that most of these names also took part in the prosecution against Ekrem İmamoğlu, the arrested mayor of Istanbul, and some other, some dozens of other members of CHP, including some 10 mayors.
Speaking of Ekrem İmamoğlu, he's being held behind bars for over a year exactly. It was March 19 last year, and it's now over 12 months, and for facing an uncertain future as well, facing perhaps the same fate. We are monitoring their case as well, the CHP, jailed CHP mayors, whose numbers are about 15 to 20, as far as I remember. It's very difficult to keep track of the fast, rapid developments. Well, fine. We will see, and we will continue to cover and discuss these developments. This is a new development. We spoke about the motion for resolution about Osman Kavala, one of Turkey's most symbolic political prisoners. A motion for resolution calling for Magnitsky sanctions, which points out, quote unquote, those who deprive Osman Kavala of his liberty. My guest was the Turkish judge Yavuz Aydın, board member of the International Justice for Rule of Law group based in Brussels. Thank you for sharing your views with me.
Thank you.